My name is David Petrosky. I'm a California attorney representing landlords with eviction cases. In each episode that I present, I will do my best to be brief and to the point, while at the same time addressing main points and providing important information for landlords. In today's video, I'll be discussing rules relating to residential security deposits in California. First, a disclaimer. The landlord-tenant rules, especially in California, change rapidly, and this video might not be updated to reflect the most current rules. Legal counsel is not given in this video, and you should obtain your own counsel before deciding on an appropriate course of action. First, just a little bit about me. I'm a California attorney representing landlords since 2004. I'm a published author and a referral source for realtors, landlords, and other attorneys, and we get results. However, of course, there's no guarantee of success on any given case. This video will outline some of the most common, but not all, of the California residential security deposit rules. This video does not discuss the reasons or the purposes that a deposit can be used for, as that is the topic of another video. Although this video doesn't address all of the security deposit rules, this video does seek to outline some of the most common security deposit rules that are often areas of contention between landlords and tenants. One common question is how much of a security deposit a landlord can collect at the commencement of a tenancy. If the property is unfurnished, the landlord can collect up to 2 times the monthly rent. If the property is furnished, the landlord can collect up to 3 times the monthly rent. These amounts are in addition to any rent for the first month paid on or before the initial tenancy. Another common question has to do with the initial inspection at the end of a tenancy. Within a reasonable amount of time after notification of either party's intention to terminate the tenancy or before the end of the lease term, the landlord shall notify the tenant in writing of the tenant's option to request an initial inspection and of the tenant's right to be present at that inspection. These initial inspection rules do not apply if the reason for termination of tenancy has to do with CCP section 1161(2), 3, or 4, which generally are terminations due to non-payment of rent, violations of the rental agreement, or causing damage or nuisance at the property. At a reasonable time, but no earlier than 2 weeks before the termination or the end of the lease date, the landlord or the agent of the landlord shall, upon the request of the tenant, make an initial inspection of the premises. The purpose of the initial inspection shall be to allow the tenant an opportunity to remedy identified deficiencies in a manner consistent with the rights and obligations of the parties under the rental agreement and in order to avoid deductions from the security deposit. If an initial inspection is requested, the party shall attempt to schedule the inspection at a mutually acceptable date and time. Based on the inspection, the landlord shall give the tenant an itemized statement specifying the repairs or the cleanings that are proposed to be the basis of any deductions from the security deposit that the landlord intends to make. The statement shall be given to the tenant if the tenant's present for the inspection, or it shall be left inside the premises. The tenant shall have an opportunity during the period following the initial inspection and up until the termination of the tenancy to remedy any identified deficiencies in a manner consistent with the rights and obligations of the parties under the rental agreement in order to avoid deductions from the security deposit. Next, I want to talk about the disposition of the security deposit after the tenant has vacated the property, as this is an issue that is heavily contested in many cases. Within 21 days after the tenant has vacated the property, the landlord shall furnish the tenant with an itemized statement regarding the security deposit. The landlord shall return any remaining balance to the tenant within the same time frame. Along with the itemized statement, the landlord shall also include copies of documents showing any charges incurred and deductions taken by the landlord to repair or clean the premises. This could include payment receipts or invoices. There are several other important security deposit facts that landlords and tenants should know. A landlord cannot charge a tenant for ordinary wear and tear or for pre-existing conditions that existed prior to the tenancy. Any notices relating to the security deposit should be sent to the address provided by the tenant or if the tenant does not provide an address, then any mailing should be sent to the address that was vacated. No lease or rental agreement may contain a provision characterizing any security as non-refundable. If a landlord is non-compliant with these security deposit rules, there are consequences. The bad faith retention of the security deposit may subject the landlord to statutory damages of up to twice the amount of the deposit, in addition to any actual damages. And the landlord has the burden of proof as to the reasonableness of any amounts claimed. If you find these videos useful and want to be informed when new videos are uploaded, please subscribe to our channel. You can also visit us on our website, attorneydavid.com. We publish many articles on our blog. You can also schedule a consultation at the website, attorneydavid.com. We also post updates on Facebook and Twitter regularly. Thank you so much.